This is Deepya MS. My registration number is 2112311 and this is the explanation of the case law SK Kabir versus Narayandas Lachman Das Ltd on 13th August of 1954. The first appeal has been filed by the two plaintiffs against the judgment and decree dated 20th January 1949 of Sri Dinabandhu Das, District Judge of Konchhar, Balasur, arising out of a suit brought by the plaintiffs claiming damages to the extent of Rs 15,000 against the defendants for breach of contracts. The two plaintiffs are dealers in mustard oil at Balasur and the defendants constitute a firm dealing in mustard oil at Kanpur. The defendants entered into two contracts with the plaintiffs, first on 5th April 1943 and the other one on 21st April 1943. The first contract was to supply 1056 tins of mustard oil at the rate of 29 rupees per mount, and the second contract was to supply 286 tins of mustard oil at the rate of 36 rupees per mount. The plaintiffs paid an advance of 1000 rupees through a bank draft and dispatched 1519 empty tins to the defendants. The defendants avoided performance of the said contracts on the false pretext that the export of mustard oil outside the United Provinces had been banned. The plaintiffs found that there was indeed no ban on the export of mustard oil after inquiry. With this information, the second plaintiff and the lawyer Sri Patnaik approached the defendant's firm for taking delivery of the articles, but the defendant's firm refused to deliver and finally cancelled the contracts on 14 July 1943 on the pretext of the aforesaid ban. The plaintiffs calculated the damage on the basis of difference of prices to be 9,986 rupees. They also claimed the price of the tins at 3,987 rupees and for refund of the advance of 1,000 rupees, a total of 14,973 rupees. The defendant argued that the contracts, if any, became impossible of performance due to the existence of the legal ban issued by the government of United Provinces. Further alleged, neither of the plaintiffs nor their pleader ever approached them for taking delivery of the tins of the mustard oil, and the defendants, having waited for 3 months, were finally compelled to cancel the order booked with their firm and have sent a check for 796 rupees towards the sum of 1000 rupees received from the plaintiffs, deducting an amount of 203 rupees as their cost. The court at Balasur has no jurisdiction as no part of the cause of the action arose within the jurisdiction at the Balasur court. The main defense is that the suit is hid by the provisions of Section 69 Partnership Act, as the plaintiffs constitute a firm which has not been registered and the persons suing are not shown on the register of firms as partners in the firm. The learned district judge found that the refusal on the part of the defendant's firm on 21st July 1943 to deliver the goods to the plaintiffs at Kanpur when the second plaintiff with their lawyer approached the defendants is a willful breach of the contracts and the cancellation of the contracts is wrongful. The district magistrate of Kanpur, who endorsed on the said letter that there was no ban of the export of mustard oil. It has been found by the learned district judge that the court at Balasur has jurisdiction as part of the cause of action arose within his jurisdiction. Now to the main issue. The present plaintiffs are Mohammedans and are two brothers being joint in mess, residence and property. Is this a partnership? Is this a registered firm? Section 69, subsection 2, Partnership Act runs as follows. No suit to enforce a right arising from a contract shall be instituted in any court by or on behalf of a firm against any third party unless the firm is registered and the persons suing are or have been shown in the register of firms as the partners in the firm. Partnership has been defined in Section 4 as follows. Partnership is a relation between partners who have agreed to share the profits of a business carried on by all or any of them acting for all. Persons who have entered into partnership with one another are called individually partners and collectively a firm, and the name under which their business is carried on is called the firm name. Certain tests have been laid down in Section 6 for determining whether a group of persons is or is not a firm. It provides that regard shall be held to the real relation between the parties as shown by all the relevant facts taken together. The two explanations in the said section are important. They say that the sharing profits or receiving a share of the profit does not of itself make them partners. A fair number of letters written by the plaintiffs were submitted. Extract 36. A letter dated 7th August 1943 from Balasur to the defendants purports to have been written on behalf of both SK Kabir and SK Alam clearly mentions the man who went to you, the defendants, was one of the partners of the firm. One more feature in the present case is also made clear by the reference to Extract 2 and the evidence of prosecution witness 1, the clerk of the plaintiffs. Extract 2 is a profit and loss statement of SK Alam and SK Kabir from broker for the year 1943 to 1944. And the statement of prosecution witness 1 runs to the effect the plaintiffs are joint in mess and all their business is joint. Therefore, they jointly share in profits and losses of the oil business also. So yes, they are a partnership, but no, they are not a registered firm. The facts being that the parties are two Mohammedan brothers and they were carrying on the business under the trade name of the firm, and there is absolutely unimpeachable evidence that they were sharing the profits of the business. Further, it appears from the admitted correspondence that one of the plaintiffs was acting on behalf of both in the business and was representing himself as a partner. These circumstances lead us to infer that there must be an implied agreement of partnership between the parties. To constitute a partnership, we would therefore agree with the learned court below and find that the plaintiff suit is hid by the mischief of the provisions of Section 69 the Partnership Act. As the suit is hid by the provisions of Section 69 Partnership Act, the plaintiff suit is bound to fail and therefore the appeal is dismissed with costs. Thank you.